Legal dictation start. The allotment of plots under Austri's policy be restricted to the claimants within the sector for which the land has been is being acquired full stop. The learned Advocate General Haryana firstly relied upon the following statement in the policy dated 28/8/1998 full stop. This amendment provisions will be made applicable prospectively full stop. This provision does not make any difference for any oustee's claim to the allotment of a plot under the oustee quota does not get extinguished even if it is not made when the oustee could have applied for the same full stop. This is clear from paragraphs 49 and 50 of the judgment in Sandeep's case, which we set out earlier full stop. Thus, the oustee would be entitled to the allotment of a plot in the next residential sector if the plot under the oustee policy cannot be offered to the oustee in the same sector by virtue of the policy dated 28/8/1998 itself. Full stop. It is also important to note that the policy dated 28/8/1998 expressly states that it is in partial modification of the 12/3/1993 policy full stop. In other words, it is not a fresh policy full stop. If the right of an oustee to the allotment of a plot is not extinguished, even if he does not apply for the same when he could have, it would follow that the right would be governed at the relevant time by the earlier policies but as modified by the policy dated 28/1998 full stop. There is in fact nothing in any of these policies that suggest the contrary full stop. The policies do not suggest that the state of Haryana or the Hudda intended discriminating between the oustees inter se in this regard and in this manner full stop. There is in fact no intelligible differentia in this regard between the oustees who do not get the plots for no fault of theirs and the other oustees who alone, according to the Advocate General, are entitled to the plots on account of their lands having been acquired for the four specific purposes full stop. The learned Advocate General submitted that the policy dated 28/1998 would operate only where the land acquired from the oustee is used for the four purposes mentioned therein, namely residential sector, recreational sector, institutional zones, group housing societies, and industrial purposes full stop. In other words, according to him, under this policy, an oustee would be entitled to the allotment of a plot in a sector other than the sector from which his property was acquired only if the sector from which the oustee's land is acquired is used for these purposes full stop.